Okay.
Yeah, go ahead and start whenever you're ready.
Oh, okay. Thanks, Anna.
Yeah.
Awesome. So I have the chat open just because I feel like that's the only way I could really interact with folks that are on or attending. I just want to introduce myself. My name is Jasmine Poyawan. I'm the new senior staff attorney here at LCCRSF with our economic justice team. Here filling in for our staff attorney, Julie Gilgoff, who typically provides workshops and webinars through our Legal Services for Entrepreneurs program, which I'll talk a little bit about later. She's on vacation, so here filling in to talk about today, knowing your rights as a commercial tenant. As commercial tenants are facing the possibility of commercial evictions, as well as the issue of paying back rent that was due during the pandemic and even currently. And so we want to make sure that our target audience, commercial tenants all over the Bay Area, are informed of the laws, are informed of their rights should any lawsuit be filed against them by a landlord. And so before I start, I just want to get kind of a temperature check for who's on the webinar. And you can enter it in on the chat, but I'd love to hear for any small business owners that are on here, where are you located? What city is your business located in? All right, so I'll keep track on the chat, but the reason why I ask is because we'll be focusing a little bit more on some of the laws in San Francisco, Oakland, Berkeley, Alameda County generally. But I'd love to just to learn more about who's attending and who also just might have specific questions based on locale. So with that, I do want to give a few disclaimers.
Jasmine?
Oh, yes.
Sorry, before you keep going, I want to make sure that the interpretation is working.
Yes.
Is someone on the Chinese line that can raise their hand on the any of the participants that can raise their hand? I just want to make sure it's working. It's not working. Okay. Give me a second. Let me, sorry about that.
I'm the senior attorney here at LCCRSF's economic justice practice. I'm filling in for our staff attorney, Julie Gilgoff, who leads our legal services for entrepreneurs program. And part of that program is we are hoping to provide Know Your Rights webinars to commercial tenants in light of the potential commercial evictions and also rent due from pandemic and a lot of the struggles that small businesses and sole proprietors have experienced the past 2 years. And so before I start, just want to give some context. During the pandemic, so March 2020, when our governor, Gavin Newsom, entered in a state of emergency due to COVID, there was both residential and commercial eviction moratoria passed all throughout the state of California. Today, we're going to focus on businesses in the greater Bay Area with specific information for San Francisco, Oakland, Berkeley, and Alameda County in general. For those who might not have might have needed interpretation, if you'd like to participate, I'd love to hear where your business is located. Feel free to type that in the chat. It gives me a better idea and better sense of where to focus some of the time and information. So starting in September starting September 30th, 2021, so quite recently, the eviction moratoria expired. So in a lot, like the statewide moratorium expired. In the Bay Area, there are no more protections based on this moratorium. There are certain exceptions, which we'll talk about today in the different cities. But for the most part, businesses, small businesses and nonprofits are no longer protected from evictions based on what we call non-payment of rent. And so we'll get to that later. But the big question here is, what can you all do given this context? And we'll talk about that today. Disclaimers, though. First, no, I'm an attorney, but this is not legal advice. We're just providing information. If you need legal advice or in search of that, we'll have commercial lease consultations available, have resources at the end of the presentation. Another disclaimer that's not on here is that this presentation is very text heavy. There's a lot of text on the slides. I don't expect folks to read, keep up with everything. I'm going to be summarizing, including myself. So I'm going to be summarizing the broad strokes and really hopefully give you all very important takeaways on how to protect yourself against potential lawsuits from your landlord. With that, we're going to start with California, or with San Francisco. So like I said in the beginning, there is no longer protection against non-payment of rent. So not paying your rent due to COVID. But in San Francisco, there is still something called a forbearance period. And so this was passed back in December 2020, where the San Francisco Board of Supervisors created 4 tiers or types of commercial tenants. And so depending on how many of employees you have will affect how long you have as a forbearance period. For instance, tier 1, if you're a very small business with 10 or fewer full-time employees, and you're in San Francisco, you will have up to 2 years to repay your deferred rent. So the rent that was due during the state of emergency. So up until September 30th, 2021. And you can work that out with your landlord on how to best repay that rent. You also have the option to terminate your lease by giving your landlord 30 days notice. So if, let's say, you don't want to be in your lease, maybe you sold your business, or maybe you just want to go out of business, you can give your landlord 30 days notice. You must pay all the rent due through whatever that date of termination is. The good thing, though, is that landlords can't assess any penalties or fees in connection with the termination prior to September 30th, 2021. So you were to terminate your lease up until September 30, 2021, landlords are not allowed to put a penalty or a fee on the back paid rent. And so the other tiers are very similar. You just get less time. So the more employees you have, the less time you have to pay your deferred rent. As you can see on the slide, 10 to 24 employees, you have up to 18 months, 25 to 49, you have up to 12 months. And then if you have 50 to 99 employees, you have up to 6 months. And so, it's most of our attendees, most of our clients are typically in the tier 1 or tier 2 range. So it's probably what's applicable to you. Another thing in San Francisco, and I'm going to focus a little bit more on San Francisco, given that we have a small business owner in San Francisco, is what we call the rebuttable, or what's called the rebuttable presumption. So Mayor Breed signed an amendment to an ordinance on August 4th, 2021, which basically says that if you're a commercial tenant, a small business owner, that was forced to shut down your business due to government policy, for instance, barbershops, salons, nail spas, were forced to shut down for a period during the pandemic in 2020. This rebuttable presumption says that if you fall into that category, then you are excused from having to pay rent during that time period. So let's say from May 2020 to September 2020, you couldn't run your business because you had to shut down because you own a nail spa. Then under this law, under this presumption, you would be excused from paying that rent. And this is very important, especially for San Francisco businesses, to kind of raise this concern, which we'll talk about later in the lawsuit process. Obviously, there's still risks for eviction, not just in San Francisco, but anywhere else in California. The commercial eviction moratoriums only protect commercial tenants from evictions due to non-payment of rent. So evictions from not paying your rent. But it doesn't mean that a landlord still can't evict you for, let's say, if your business is creating a nuisance, or let's say your lease has expired, or you breached your lease agreement in other ways. The landlord can still evict you. And so we won't be covering those instances on today's webinar, but if that's something that's applicable to you, then please feel free to take use of our resources at the end of this presentation. And then again, the moratorium and the deferred rent is only from March 2020 to September 2021, so the end of September 2021. So starting October 1st, any rent due, so from October and November, like that doesn't fall within the purview of these policies. So you'll have to pay rent on time for those months. And so that's San Francisco. In Alameda County, which we don't see anyone who stated that they're in Alameda County, but we'll go over this anyway. There are less protections, unfortunately, but there are some nuances. So in City of Oakland, they don't really have a strong policy. They do encourage landlords to negotiate and come up with a repayment agreement with their tenants. There are a lot of resources on the City of Oakland's website where they actually refer folks to our webinars, refer folks to legal resources, which a lot of the resources we'll share too at the end. But if you're in the City of Berkeley does give a deferment of up to 12 months to commercial tenants. This is something that's pretty broad, and so really important if you're in the City of Berkeley or operating a business in the City of Berkeley that you have at least up to 12 months. And so when you're negotiating with your landlord and figuring out how to repay rent, this is great leverage for you. So outside of this, let's say you get to the lawsuit stage. In Alameda County, there are available legal resources. The Alameda County Superior Court Self-Help Center offers phone and video consultations, as well as live chat. You can talk to attorney and legal workers who can provide legal information to help guide you through a lawsuit. If you are a limited liability company or a corporation, then you would need to hire a lawyer to represent you. And in that case, the Alameda County Bar Association offers referrals to private lawyers. And also, I believe it's either the first or second Saturday of every month, they do provide free virtual clinics where you can consult with a lawyer. So there are pretty robust resources available. So we're getting to the point of talking about a lawsuit. So we're going to assume that landlord might file a lawsuit to either evict or to collect their late rent. And so the rest of this presentation is going to focus on the overview of what we call the unlawful detainer process. So that's just legal speak for eviction process. So the unlawful detainer or UD process is a lot of steps, which we're going to break down a little bit. And because at LCCRSF, we really try to gear our services toward tenants and really advocate for small businesses and nonprofits, I'll be giving some tips on along the way of describing this overview and this process on how to protect yourself as a small business owner or nonprofit. And so I won't read this slide since it kind of we'll go over this. But the first step, and this is from the landlord's perspective, like the first step that the landlord needs to take. And this is important that as tenants you understand what the landlord needs to do legally, because if the landlord does not follow all of the correct steps, then that is a sufficient legal defense as a tenant. Because in the state of California, landlords are required to legally and formally evict tenants, meaning that they can't just lock you out of your building. That is illegal. That is not following the correct process. So if that's something that has happened to you or you've heard of, then please, let us know here at LCCRSF or find other resources. But the first step is that the landlord must give you what's called a 3-day notice to pay rent or quit. What that means is that they haven't filed a lawsuit yet. This is before they file a lawsuit. They're required by law to give you 3 days notice, so meaning 3 days. That excludes Saturdays, that also excludes Sundays and holidays. So calendar days outside of those days, you have 3 days to either pay all of the rent that they're asking for or to leave. Those are two options. Other option is to not leave, to not pay back your rent, and to wait for them to file a lawsuit. So why is this stage very important? Well, this stage is very important because if the landlord does not provide you a sufficient 3-day notice, meaning the 3-day notice is defective, it doesn't have the date of the demand, it doesn't have the name and address of the tenants, it doesn't have the correct rent amount that's due, like it needs to state the rent amount. And then it also needs to be served to you, the tenant, in the correct format. Because if it doesn't have everything and all of these components, then the notice is defective, and you can use that as a defense in a lawsuit to say, well, the landlord didn't follow the 3-day notice requirements. What will happen is that the landlord will have to file and go through the process from the beginning. So again, please pay attention to that 3-day notice. Please make sure that the landlord actually gives you 3 days, because that is very important, crucial step. And so I'm going to be talking about service a lot. So just because a landlord tells you that they gave you a notice or tells you that they're going to file a lawsuit, it really doesn't matter in the face of a court or legal system unless they legally serve you the paperwork or legally give you the paperwork. And a 3-day notice can be given in 3 different ways. One, it can be given personally. So if an adult or a landlord gives you the actual 3-day notice, that's personally served to you. It could also be left with a person who's above the age of 18 at your business. If they do that, they also have to mail you a copy of the notice to you. Or if they can't find a person to give a notice to, then they can just put the notice on your business in a place where it's reasonable for you to see it. They could place it on your building, but then they would also, again, have to mail you a copy. And so these are the three ways. If you never receive something, if they don't have proof of service, then again, this is another defense to say, no, this lawsuit needs to get thrown out. It wasn't properly served. So let's say the 3-day notice was sufficient, it was served properly. What are your responses? What can you do? Well, like I said, you can pay the rent that they're asking for. If you choose not to, you could also negotiate. There's always room to negotiate a settlement with your landlord. We actually encourage this since, unfortunately, there aren't very many protections for commercial tenants under the law. So a lot of times when you are trying to talk with your landlord, it really comes down to your relationship with your landlord and your ability to negotiate a mutually beneficial agreement. And at any stage, you can always negotiate a settlement, whether it be during this 3-day notice stage, whether it be at during the lawsuit. We always advise to try to communicate with your landlord. The third thing, let's say you're not interested in paying any of the rent, not interested in negotiating with the landlord, you could move out of the rental unit, so you can move your business out. Or you could choose neither, and you could choose not to pay rent, you could choose not to move out. And in that case, you're just probably going to wait for the lawsuit paperwork to be served to you. And we'll get to that stage. Let's see. So the next step is a summons and complaint. So when a summons and complaint for an unlawful detainer lawsuit is filed and served to you as the tenant, then that means your lawsuit has started. Again, if your landlord gives you a 3-day notice, that doesn't mean that there's a lawsuit against you. It only means that there's a lawsuit against you if you've actually been properly served a summons and complaint. And so what is a summons and complaint? Summons and complaint are just two separate court forms, very kind of straightforward forms that ask questions about kind of what is this lawsuit, and the landlord has to fill it out and explain sort of what they're asking for, what relief they're asking for from the judge, the details about your business, the details just about kind of the history of the dispute, and they file that. And so if they file the summons and complaint and properly serve it to you, then you as a tenant have only 5 court dates. So meaning 5 calendar days that don't include Saturday, Sunday, or holidays, after receiving the summons and complaint to file the next step, which is called the answer. And we'll talk about that later. But let's say you don't. Let's say you get a summons and complaint and you just ignore it. We highly, highly, highly urge people not to ignore summons and complaint, because what can happen is that you can get a default judgment against you, meaning that by default, the landlord wins the case. And if they win their case, then one, you can get kicked out of your property, but also it could look really bad on your credit report and make it harder for you to rent another place in the future. And so we always say, when you receive a summons complaint, make sure to respond to it as soon as you can. But going back to the delivery of summons and complaint, remember I said it needs to be properly served. What this means is that the summons and complaint can be served to you personally. So literally an adult can give you the legal paperwork. It can also be served by substituted service, which we'll talk about, posting and mailing service, or a lease designated service. And we'll talk about what these types of services are. But the takeaway here is that just like the 3-day notice, the summons and complaint must be properly served. If they are not properly served, then that is a legal defense for you to provide in your answer as to why the lawsuit should be thrown out. So this next slide, very, very text heavy. So I'm just going to summarize a little bit, and we could have a Q&A at the end where if folks still have questions. But basically, again, personal service is when the landlord or a person who is hired to serve you just gives you the paperwork personally. Substituted service is very much like the 3-day notice service, where they give the paperwork to someone who's above the age of 18. And if they do that, and they're at your residence, they must also mail you a copy, a second copy. This is very important because the service, the date of notice doesn't start when they give it to another person. It starts when they actually mail that second copy. And the same thing is from posting and mailing service. So the posting and mailing service is that they just post the legal paperwork on your business building where they can make sure reasonably that you'll see it. But when they do that, they must also mail a copy to you. And the day of notice starts when they mail that copy, not when they post it on your building. The last type of service, and this is really important, we call it the lease designated service. Some commercial leases will have a provision specifically outlining what the process of service and notice is required for a lawsuit. So it's very good to check your commercial lease, review it to see if there are any specific ways outlined of how service or notice is supposed to be given to you by your landlord. This is important because the lease will overrule the law. So meaning that, let's say you get 5 days, or let's say you get there's personal service or substituted service, but your lease says only personal service, then that means that the lease rules. So that means that the landlord has to give you personal service. Cool. So I talked about this, what a court day is. Again, a court day does not include holidays or judicial holidays. But let's talk about this really quickly. If you were served by personal service, so if someone gave it to you personally, you have 5 days to respond with your answer. But any other way, so let's say it was substituted service where they had to mail you a copy, or posting on your building where they also have to mail you a copy, you are allowed 15 days after the date that second copy was mailed to you to respond. So that's very important to know that those two types of services will actually give you more time to answer. We won't fully talk about this, but this is just kind of what's required for substituted service. The landlord can't just give it to any other person. They need to show that they actually made a effort to give it to you personally. So the reason why it's really good to understand this is if you're trying to create a legal defense saying, well, I wasn't served properly, you can explain that, you know, they didn't even give me a chance to get personally served. And these are just different ways. And so This is not very important right now, but just know that for substituted service, there are very specific rules and processes that the landlord must follow. Alrighty, next stage here is your answer, which is very important. I want to give enough time for questions and answers. So I will kind of go through these next few slides a little quickly, but at any point that I'm going too fast, please let me know on the chat. But very important, how to answer, right? So I've been telling you that you only have 5 days or maybe 15 days, depending on the service. And it's very important to answer, because if you don't answer, then you just lose by default. So how do you answer? Well, there's a standard form, the UD 105, and you can see all of these forms online. They're public, they're available to you. It's very important to remember that if you have a limited liability company or any other type of corporation, and the landlord named your LLC or your corporation as a defendant, then you must be represented by an attorney. On the other hand, if you don't have an LLC, or if you don't have a corporation, or your landlord just named you as an individual as the defendant, then you can actually represent yourself, which could be cost effective. Regardless, it is good to always try to consult with an attorney, and there are pro bono opportunities available. And the reason why we say it's good to consult an attorney is because in your answer, you have the opportunity to provide what we call denials and defenses. So a denial is something that you are responding directly to the summons and complaint. You are denying the facts that the landlord is stating. Let's say the landlord on their summons and complaint says you owe $3,000 in back rent. You can deny that and say, actually, I don't owe $3,000. I owe $1,000 for XYZ reason. That would constitute as a denial. In addition to denials, you also have defenses, which I've been throwing around that word a lot up until this point. And the reason being is that your legal defenses are your reasons as to why you should not be evicted, right? And we already talked about some of those reasons of, well, the landlord didn't follow the correct process of serving my 3-day notice, or the 3-day notice was insufficient, or the landlord actually didn't serve my summons and complaint. Those are all defenses that a judge will take a look at and listen to when deciding your lawsuit. There are other defenses too. I will go over them briefly, but depending on your commercial lease, you might have something what's called a force majeure clause, which is a provision that states that you don't have to perform your lease, so you don't have to pay rent, if there is some sort of circumstance out of your control. So that could be, COVID, that could be the pandemic, that could be a natural disaster, etc. A lot of leases don't have this clause, but it's very, very advisable to look at your lease, because you might have it, and you could argue that you weren't able to perform your side of the lease because of this unforeseeable incident, the COVID pandemic. Very similar to a force majeure clause. Let's say you don't have one. You can argue a defense called the commercial frustration of purpose. What this means is that the purpose of the contract was frustrated or made impossible, so to speak, right? The purpose of the contract was for you to do your business, but you're arguing that I couldn't do my business because my business was shut down. If that's the case, then you can argue commercial frustration of purpose. And that's what the San Francisco ordinance with its rebuttable presumption is effectively doing. So San Francisco is making that argument for you, but even if you're not in San Francisco, you could still make that argument as a legal defense that you don't need to pay or rent or perform under this contract because your whole business purpose or your purpose for the contract was frustrated by COVID and the government policy is shutting down your business. Yeah, so to file an answer, unfortunately, is a bit pricey. Last time I checked, I think it's about 400 something odd dollars to file your answer. Some folks might qualify for a fee waiver if you're receiving any public benefits, if your household income before taxes falls under a certain threshold, you could have your fees waived. Just know that if you go to self-help center or you're online trying to print out paperwork, to just search for fee waiver if you believe you qualify. And like your landlord, if you file an answer, you must also serve that answer to your landlord. You can't just file it and be done with it. You also have to either personally serve your landlord, you can serve it to your landlord substituted service like we talked about. But basically you need to make copies of your answer because one copy you'll keep for yourself, another copy you'll actually file with the court, and the other copy you need to serve to your landlord. And again, if you don't do this properly, then that's something your landlord can come back at you and say, well, I never received your answer. And so a lot of the lawsuit is very procedural as well. So things you just need to be aware of. So let's say you file the answer, everything's great. What happens then? Then you can, either you or your landlord could set a trial date. This is basically just asking the judge to set a date for trial, which could either just be looked at by the judge or decided by a jury. So it takes about 20 days more or less to get your court date after a request is made. And so depending on how quickly things go, an unlawful detainer lawsuit can actually go pretty quickly. So what happens in between the time of filing your answer and your trial date? Both sides or either sides can request evidence. And this is done through what we call the discovery process, where either side can request the other side to provide information. So landlord could ask you for your bank statements to prove that you actually weren't making any money, or you can request information from your landlord based on kind of the facts and circumstances of your case. Let's say the landlord, though, requests all this information and you don't think it's appropriate for them to do that. You can object to an evidence request. You can argue that the evidence is irrelevant. It has no matter in your case. You can object that it's vague or overly broad, meaning that, let's say, giving your financial information, all of it is just too much, like it has way more to do than just your business. You can also argue that your information is protected, private, or confidential. There are a number of objections that you can make. And so again, please, like if you're in the trial stage, please consult an attorney to make sure that you can protect yourself and really establish your rights. In addition to evidence, you can call up witnesses. Witnesses come to your trial date with you. They usually wait in the hall and get called in. It's not as dramatic as the legal TV shows, but they are helpful depending on the circumstance. And again, you have the ability to call up witnesses. The landlord has the ability to do so as well. So just be very aware of that. I want to stress this again. So settlement, I said in the beginning, at any stage of your dealings with your landlord, you can come up with a settlement. It can be before the 3-day notice. It can be after the 3-day notice. But on the day of your trial, the judge will give you like the last opportunity to meet with the other side, with the landlord, to reach a settlement, because the judge really just wants you all to avoid trial, avoid conflict if possible. And if you reach a settlement, it's sometimes better because you get to control those circumstances versus having a judge or a jury determine what's right and beneficial for you all. So really just kind of weighing the pros and cons. Settlement is always just something to think about at every stage of the lawsuit. But yeah, I'm aiming to end here at 3:50 to give you all 10 minutes for Q&A. But this last couple of slides here is kind of the worst case scenario. Let's say you lose your lawsuit and there's a judgment against you, meaning that the landlord wins, right? They get their judgment to the rent due. They're also given the ability to evict you. What happens then? Well, if that's the case, what happens is the landlord gets what's called a judgment of possession, meaning that the court decides that, okay, landlord can take back the commercial property. You can no longer occupy it. It doesn't mean that you need to leave right away. There's still a process. And that process is that the landlord has to fill out what's called a writ of execution and take it to the sheriff's office. And the county sheriff, will give you what's called a notice to vacate, which gives you 5 days to move. So you're not going to be required to move the same day. You will at the very, very least get 5 days to move your things. Depending on your circumstances, you can ask for what's called a stay of execution, meaning an extension of that 5 days up to 40 days. You will have to pay rent throughout that time. So it's prorated rent. So just because you get that doesn't mean that it might not mean that it's beneficial for you, but it's just something to consider. If in that case, if you surpass your 40 days or your 5 days, what happens then is the sheriff can actually lock you out, remove all your things, and literally remove it from the property. And so just being aware of these timelines, I think, is very important, and also being very aware of the process and the necessity of getting the sheriff involved. So just because you lose your lawsuit doesn't mean that your landlord can take matters into their own hands. So that was a lot of information, and sorry for just talking at all of you. It's not usually my my preference, but I'm looking forward to your questions if there are any. Before we do that, I'm going to leave this slide up. These are just the lawyer referral resources that I promised throughout the presentation. The first referral resource is obviously our Legal Services for Entrepreneurs program here at LCCRSF. Here, there's a link, which I believe we can send this presentation out to all the participants. But if you click on this link, we have an online application form in which you can fill out. That'll be the first step to getting into our system. And from there, we can determine whether we can represent yourselves, whether we should refer you to a clinic or connect you with pro bono legal support. Highly encourage you to apply if you're in need of our services. If you are sued as an Alameda County resident, like I said, the Alameda County Superior Self-Help Center, located, I believe, either in Oakland and Hayward, is available. They give pretty robust resources and can really walk you through the court forms that you need. If you need private lawyer, if you're like an LLC or a corporation, Alameda County Bar Association can refer you to any lawyer, honestly, in the Greater Bay Area. There's also the San Francisco Bar Association. And then let's say you don't need a lawyer, you just want to negotiate and you need that support to negotiate with your landlord. In San Francisco, there's conflict intervention services that provides mediation support to help tenants and landlords reach a rent repayment plan or settlement. And in this case, CIS is working with the city of San Francisco as well. And so they're very aware of kind of laws and the protections that tenants have. But with that, I will open this up to Q&A. Suppose if you have a question, you can just drop it in the chat. Yeah, Anna, if you wanted to facilitate this part or how it's usually done, but thank you all just for listening in. I hope some of this information was helpful. Oh, I see a question. So from Jeffrey, my business is a sole owner LLC. So it really depends on who is the named defendant in your on the summons and complaint. So if you are named as a defendant as an individual, then you can represent yourself. But let's say your LLC has its separate identity, its separate name, and that's named as a defendant, then you will need a lawyer to represent you. I hope that helps.
Doesn't look like there's any other questions. Like I mentioned, feel free to reach out to us if you need some support. I'll drop my my email address again in the chat box. And then you can also apply to our services. I'll send the application as well. We have clinics once to twice a month. And we can support you in the legal clinics with the commercial lease issues. And if you need a consultation as well, we have some capacity to support with consultations that are not on the clinic dates. But thank you so much, everyone, and thank you so much to our interpreter for coming and supporting us today. Thank you so much, Jasmine. I think you did an amazing job of presenting all the information.
Thanks, Anna. I really appreciate it. Thanks to everyone for attending, and thank you, Kevin, for interpreting.
I'm going to go ahead and end the webinar now. And